Thanks for showing up for this. I should say at the outset, if anyone is expecting some answers today, they may be disappointed because there are a lot of questions at this stage when it comes to VR and how it's going to be treated legally and what the outcomes may be of different legal questions, but not that many answers. What we can do is talk about the questions and we can talk about some of the risks. Briefly, media technology lawyer in San Francisco and Los Angeles, and increasingly work with VR companies, long experience working with video games companies as well. So this is the new world. The technology and the content are developing very quickly, as everyone knows. The law, of course, not developing quite so quickly, as has been the trend with so many other technologies. New business models, new transactions, new approaches, and the legislators, as we'll see in a moment, are quite far behind the curve, and certainly the courts as well. The question for all of us is how we can take advantage of the opportunities in this new space while limiting our risk. We'll talk about 8 things here in the next 19 minutes or so. First of all, clearance of VR content, privacy concerns, copyright and trademark issues, real-world legal risks of AR apps, health and safety concerns for users, the possibility of regulation on the horizon very soon, possibly, the importance of being alert to legal developments and public perceptions, and finally, social VR and the unique risks that that could bring. First of all, you know, it sounds obvious, but you know, when you're in the thick of things, it may be something that is overlooked, and that's the fact that when it comes time to prepare to launch your VR content, there is a whole lot more content that needs to be cleared by your legal department, and this was brought home to me last year. I was at a VR event, standing on a nice outdoor patio in LA, overlooking the ocean, and this guy was just making this very point to me. He was saying, imagine that, you know, we're in some documentary VR experience, you know, and the focus is our conversation, but in fact, you know, you've got to clear everything. You've got to clear, you know, there's a bar over there with like some bottles and labels. There's a speaker over here. You know, there's some corporate logos over here, a hotel name over here. So there's a lot to think about, both audio and visual content, and obviously a lot more that needs to go through your legal process before it can be launched. Privacy in VR, and this is something that hasn't received too much attention yet, but it's really, really important. This is, you know, the first technology where we are actually able to capture things like the user's dimensions, where the user's eyes move within the screen. You know, I think the latter, I think, is quite significant, and the example that I give is you presented the user with a 360-degree panorama of content, and you know, it could be that you have, I mean, let's say it's a game. There's some battle going on in this part of the screen, you know, let's say point 0, and over here at point 90, there's some salacious activity taking place, and you know, the company, the VR provider is actually going to be tracking where that person's eyes are going and how long they're staying there. Is this individual actually watching the content that he or she signed up to watch, or is he or she actually decided that this salacious content, let's say, is of more interest to them? You know, at least since the dawn of the internet, you know, it took a click before something incriminating might come up, and usually you might know if that was going to be the case. But in VR, simply eye movements can sort of create some incriminating record. And this actually could be, you know, in the context of a game, it may not be that significant given the demographics, but if you're talking about some sort of a business application, some sort of an application that's intended to be used in a work setting, there are some concerns there. And certainly when it comes to privacy, what I have here mentioned is social environments. There's a whole lot more data that's going to be captured. Of course, we're all used to chat rooms since the dawn of the internet and similar sort of applications where users are communicating. But we're not familiar with applications in which users are actually physically in the same space, or virtually physically in the same space and communicating. And all of those communications, I think we can expect, can or could be cataloged and warehoused and potentially used for all sorts of purposes that we may not be comfortable with in the future. Copyright and trademark, this slide was stuck in my presentation. There's actually not that much in this area that is different from the media that we're more familiar with. Obviously, the example here, which was actually not my idea, but someone stuck this in, is a virtual pair of Nike sneakers a trademark violation? It almost certainly is, whether it appears in the VR or whether it appears in a two-dimensional app on your phone. There are some closer questions. Is it if it's a lesser known brand and if it's appearing off to the sidelines and not in the center of your focus, perhaps then it could be considered fair use or not a trademark violation. But these are sort of issues that many of us are already familiar with from other media. The real world risks in AR apps, and of course here we're talking about Pokemon Go at the moment. Undoubtedly there will be many more to come. And these have received quite a bit of attention in the press. People knocking on the doors of residences and wanting to be led in the backyard so that they can catch a certain Pokemon. There have been some incidents in which people have been injured. Fortunately, from what I understand, not so seriously. But you could imagine a situation where someone is seriously injured, and let's say, it's a horrible thing to think about, but you could imagine a situation in which, let's say, a 10-year-old sees a Pokemon here 10 feet ahead of him or her and goes to pursue that virtual object and finds that it's actually the middle of a road. And, I'm a bit surprised that nothing like that, at least that I've heard of, has happened so far. But in that situation, from a legal perspective, maybe there was there was a warning at the beginning of at the time the app was installed. Maybe each time it starts, it says, be aware of your surroundings and so forth. But if this product is actually instructing you in real time, in the real world setting, to go in a place of danger, who's liable? I have to believe that if some tragedy like that was to occur, it's not at all unlikely that there would be some liability found on the part of the app developer. Another question that I think is really, really interesting from a legal perspective is, because of the really intense nature of VR, unlike any other media that we have experienced before, is it not possible and maybe even likely that a court, maybe a European court, maybe a US court, could find that free speech protections that we are used to seeing in content do not apply, at least in some cases? And, of course, in the US, this is an important constitutional doctrine, the First Amendment to the US Constitution. Content is supposed to be protected against regulation based on the substance of the content. But there are exceptions. And the US Supreme Court a few years ago had the opportunity to consider a claim of an exception in the case of video games, and that, as many of you may be aware, the Brown versus Entertainment Merchants Association case, which related to sales of violent video games to underage persons. And the court actually came back quite strongly and said, many of us find this content offensive. Many of us would never want to see our children playing these games, but we are not going to remove violent video games from the scope of constitutional free speech protection. That's the principle. But there are exceptions. There have been exceptions. And this is one from 1997. where there's this book that claimed to be a manual on how to commit a murder for hire called Hitman. And in fact, there were 2 incidents where terrible crimes were committed by individuals who later told the police that they were following the instructions in this book on how to commit a murder. And in that case, the U.S. Court of Appeals said, okay, listen, we are not going to give content protection to this type of content. This is not entitled to constitutional protection. This is excluded. This can be regulated. The state can say, you cannot sell this book, you cannot publish this book. From my perspective, you know, in virtual reality, where you are actually physically being guided, physically being instructed on how to perform a particular task, you know, if you take Call of Duty or some other similar type games and you put those in VR, and undoubtedly someone is trying to do that right now, you know, it's not hard to imagine a court saying, you know, listen, if a book that gives you written instructions on how to do this is not entitled to constitutional protection, then it's just like having an instructor next to you saying, here's how you commit this crime, here's how you do this terrible act. So I think that's quite an interesting question, and we'll see if and when that is considered. Of course, user health and safety issues have received a fair amount of publicity. We're told that increasingly the risk of nausea and so forth is being resolved, but obviously there's others maybe a bit more serious, like post-traumatic stress disorder, individuals maybe who are susceptible to seizures and so forth. And, you know, are warnings enough? Are warnings going to be enough to shield the hardware manufacturer, the app developer from liability? We just don't really know at this stage. Then there's the obvious things like tripping and falling. One thing that is a concern is children, and there have been some studies, many of you may be aware, indicating that children's vision is affected disproportionately compared to adults, and perhaps even their activity in their brains, which is a significant concern for sure. Of course, we have plenty of warnings. That's Oculus. PlayStation is concerned that you not have your pet in the room, which I guess makes sense, you know, when you mention it. I probably wouldn't have thought of it. HTC wants to make sure you don't try to sit down on any virtual chairs, and so forth. These can go on and do for pages and pages. One thing we can be sure of is that regulation is coming, and this is a picture of the US Capitol, but my guess is that regulation is more likely to come first from this part of the world. There actually were hearings before the US Senate 2 months ago, and if you look at the transcript of that and the testimony, you can see that it was just largely a process of educating the US senators who were there. I suspect that none of them had probably ever experienced VR and probably knew only what they had read about in the New York Times. You know, there was no particular regulation being considered in that hearing. There were a lot of questions that indicated that these individuals were really not that aware of what the technology and what the content was. So, you know, as far as we're concerned, that is it's a risk. It's a risk because when the sort of headline case comes along, that these individuals may be inclined to impose some sort of regulation or liability in the case of courts that may actually not be justified and that may cause more harm than good. And that's when we talk about public perceptions. A longtime client of mine in the game space was the had one of the first free-to-play games, 8 years ago. And that game wound up being investigated in the United States and here in Europe. In both cases, we were able to overcome the claims that were made, but there was nothing, and there's nothing in that game that today you don't see in virtually every free-to-play app. But somehow, children spending thousands of dollars, that results in stories going up in the press, and then of course you have the Congress and the regulators calling for some sort of action. Social VR, I think this is another quite an interesting area with some unique aspects. There's very sophisticated ways that that companies can manipulate consumers when they have that ability. And one area that I think provides a possible analogy here is gambling. And the companies that produce these, let's say, video gambling machines, have done extensive studies, behavioral studies, PhDs, all that. They understand what it is that makes people pull the lever again. One very obvious thing is, there's a disproportionate number of near misses when you're playing the computerized slot machine than if you were playing an old mechanical machine. Obviously, because that tells you that you need to just try one more time and maybe you'll get it. Similarly, in the context of social VR, we have a situation where we have, you are an avatar, let's say, and there's other avatars in the room communicating. One or more of those, or maybe all of those other avatars, are actually not being run by actual humans. They are being run by bots. And studies have shown, obviously these studies are all very preliminary, but studies have shown that the impact of a VR user experiencing disapproval or experiencing approval is significant, and almost to the extent that you would find in a real-world setting, and certainly far beyond what you would just encounter in a flat screen type of setting. So the concern is that that VR companies will begin to manipulate that in order to get users to buy things, let's say, or to behave in a certain way or take certain actions either inside or outside of the virtual experience. And that's something I think we all need to be careful about and concerned about. A VR legal strategy, I think we have to just start from the premise that anything could happen. There's a lot of uncertainty, and we just have to expect that and be prepared for that. Identify the known risks, and let's just see what we can do to address those risks without getting overly excited or scared, and compartmentalize those and move on to the others. And then finally, as I mentioned before, there's this critical element of perception, and particularly in these early days of the business, what it is that we do and we produce that could result in one of these sort of scary, terrible things that winds up in the media, which gives the whole business a bad name. So another way to look at this that I think is helpful is from the big and the small risk sides. First of all, from the small side is how do I manage the current situation to minimize legal risk? And this is, I think, we're talking about the nausea issue, the risk of vision issues, tripping over furniture, that sort of thing. Those are all pretty basic, and at this point, those are largely being managed through warnings and through trying to continue to improve the technology. The larger side says, how is this evolving legal environment going to affect my business model, my hardware, my app, my VR experience within the next 1, 2, 3, or 5 years? And that relates to a whole bunch of different factors, which can be really important to keep in mind. I think we have maybe time for one question or two quick questions, if there's anyone who, yes?
Hi. There was a recent case with a game called Quiver. I don't know if you've heard about it. But basically, they have avatars that shows just heads and hands. And one player, female player, was in this game, and at the moment she shouted at someone and another avatar in the game, then everybody in the system realized that she was a female. So then she started to be followed in the game. And then when she was trapped, this male player started to, because they had like the controllers for the hands, started to tap the air of where her body would be, in a very like harassing sexually her. Would that be any sort of protection of against a behavior like that? Because obviously the company who creates this sort of content have the information about this user that's committing harassment. Is there anything that can go in a way like this to avoid?
Yeah, it's a great question and a very interesting case. I think a couple things to be said. You know, who's liable? Let's say she does suffer some real, genuine distress as a result of this. You know, clearly she has a civil right of action against those individuals who did that, if they can be identified. There is someone who can identify those individuals, and that's the the company that runs the platform, that runs the app. So will she have the ability to require that company to give up those individuals' identities? This is something we've seen in the context of other apps, and at least under U.S. law, the answer is probably yes. Going beyond that, you know, is the creator of the experience, the operator, actually responsible for her damages because it didn't include some kind of protections to prevent people from virtually getting too close to each other?
But they did actually